Hi there, how's it going?
Good, how are you?
Good. Do you know if the jail gonna sign in and have Mr. Lynn by video?
They should be soon, yes.
Okay. Mr. Thompson, we're just waiting for the jail to sign in and then we'll get started. All right, they're at the Crawford County Jail. Can you hear me okay? Sounds like you guys are muted on your end there. I couldn't hear you. Can you say something else? Hello?
I can hear you, Your Honor.
Okay, great. Thank you. All right. We'll go on the record in People versus Edward Kenneth Lynn. This is Crawford County District Court case number 26-18421-SD-1. Mr. Lynn, my name is Judge Mertz. I'm conducting this arraignment here on behalf of Judge Burmeister today. Just want to confirm you are Edward Kenneth Lynn. Is that correct?
Yes, Your Honor.
Okay. We also have Mr. Thompson here present as counsel if necessary. Mr. Lynn, you're before the court today for arraignment on two different charges. You are being arraigned on count one on the charge of open alcohol container and vehicle that alleges that on or about February 6th of 2026, you did transport or possess an alcoholic liquor in a container that was open, uncapped, or upon which the seal was broken within the passenger area of that vehicle. That is a misdemeanor that carries with it a maximum possible penalty of up to 90 days in jail and or $100 fine, community service, and substance abuse testing. Do you understand that?
Yes, Your Honor.
At count two, the crime is failure to report an accident that alleges that on or about February 6th of 2026, that you did, being the driver of a motor vehicle that was involved in an accident resulting in total damage to all property to an extent of $1,000 or more, and failed to report that accident to the nearest or most convenient police station or police officer. That is also a misdemeanor that carries with it a maximum penalty of up to 90 days and or $100 fine. Do you understand that?
Yes, Your Honor.
All right. You do have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent at a trial if you wanted to, and to not have that silence used against you, and to testify yourself if you wanted to. Do you understand your rights?
Yes, Your Honor.
You also have the right to have an attorney present at any subsequent proceedings. As I indicated, Mr. Thompson is here today, but you can hire your own attorney, or if you can't afford one, one would be appointed for you at public expense. Do you understand that?
Yes, Your Honor.
Thank you. Mr. Thompson, have you had a chance to consult with Mr. Lynn? And you're muted, Mr. Thompson.
I'm sorry, Your Honor. Yes, we did consult. We reviewed the complaint and the maximum penalties. Mr. Lynn wishes to stay on mute at this time to the charge. He intends to hire his own attorney, and we are prepared to address bond, Your Honor.
Okay, so Mr. Lynn, the court's going to enter a not guilty plea on your behalf with regard to both the charges in this case and in terms of bond, Mr. Thompson.
Thank you, Your Honor. These are two 90-day misdemeanors. We're asking the court to consider a PR bond. Mr. Lynn has strong ties to the community. He works at Lear in Roscommon. He's resided in Crawford County for over 10 years. He has parents and siblings in the area. Him and his girlfriend are expecting their first child. He advises he has no felony record and no misdemeanor record. And so we would respectfully ask for a PR bond. Thank you.
All right, given the nature of the charges here, which are both misdemeanors, both nonviolent felonies, non-assaultive, I'm sorry, both nonviolent misdemeanors, non-assaultive misdemeanors, I do think a personal recognizance bond is appropriate. The court will set that at $1,000. So Mr. Lynn, you don't have to post that money, but if you were to violate your bond conditions in any way or fail to appear for future hearings, not only is it likely that that bond would be revoked and raised, but you would also be responsible for that money. Do you understand that?
Yes, Your Honor. Of course.
All right, and so the court is also going to include all standard terms and conditions of bond. And that is going to also include, Mr. Lynn, that you not use any alcohol, marijuana, or other illegal controlled substances unless they're prescribed to you by a physician. The court is also going to order that you participate in weekly alcohol testing because there are indications that alcohol was a factor in this incident. And the court finds that that condition is necessary for public safety. And then Mr. Lynn, once you hire your attorney, it's important that that lawyer makes, they should know this, but that they make an appearance on your behalf so that they can get all the required court notices and so forth. All right, and then you'll be provided with this in writing, Mr. Lynn, but your next hearing is going to be on March 27th at 9:30. That is for a pretrial hearing. And then there'll be a status conference set for April 7th at 10 a.m. And again, you'll be provided with written notice of both of those hearings. Mr. Thompson, is there anything further we need to address here today?
Nothing further for today's record. Thank you, Your Honor.
Mr. Lynn, do you have any questions at all?
No further questions, Your Honor.
Okay. Thank you. That's all for this hearing today, and all parties are free to disconnect this time.